In this presentation, I'm going to review a judgment which was heard on December 2016. In this case, there's a number of statements made in sequential order, and some of which are very relevant to some people's current situation. The points presented within this case could be arguments, or in fact, you could even reference the case as an argument in your case. I would strongly suggest that the viewer print out the case from the link provided below this video and have it with them as I go through various points. The main issue in this appeals case is whether or not the UK government actually has the authority to dissolve a treaty with the European Union, which was put in place in the 1970s, and what effect that would have on the UK population. Many people are asking me now, because of this exit from the European Union, what happens to their legal rights or their legal standing in the country now that this European Union has been dissolved. In summary, what it means is the rights that were afforded to you prior to the exit are still in place unless the UK government specifically repeals, which means cancel, or revises the current law. What this treaty actually did was it set up a system of law that gave the European Union overriding prerogative to the current UK law. And many laws were put in place and became part of the UK legal system, or UK law if we will, and are still active today unless they've been repealed. However, any new laws that the European Union wishes to impose on member states is no longer legally binding to the UK because the UK has left the European Union. This should put many people's minds at ease, and if we go through the rest of the points in this case, you're going to find out other important bits of information. At point 28, it talks about amending certain sections of the 1972 Act. This again confirms what I said in the previous slide, that the European government no longer has overriding superiority when it comes to UK law. However, the British government can modify certain sections of current law within the UK and is no longer answerable to the European Union. Okay, so it dilutes the influence of individual member states, and it cannot be modified or ratified, as they call, by ministers unless approved by an act of Parliament. This confirms what I stated earlier. Okay, now there's certain procedures that had to take place to get rid of the European Union, or to exit, for the British government to exit the European Union. Okay, now the European Union Act 2011 repealed and replaced Section 5 and Section 6 of the 2008 Act. So we can see here again where as I stated, they have to change certain rules legally in order for you to have different rights or maybe no rights. So again, until it's been repealed or modified, there's no issue here. Okay? A statement relating to the treaty or decision had to be laid before Parliament, and the treaty or decision had to be approved by statute. Okay? So again, confirming that they can't just say, okay, we've exited the European Union and you lose all your rights. It doesn't happen that way. Okay? Now, if you look at Section 7 to 10 of the 2011 Act, contain further restrictions on ministers voting in favor of certain measures under the TEU and the TFEU without prior approval of Parliament. So again, they can't do anything unless Parliament approves. Okay, now in 2015, a general election to hold a referendum on the issues of EU membership. This is where the government asked the public to state whether or not they wish to remain part of the EU or not. And then it was eventually laid before Parliament, which became the 2015 Act. Section 1 provided that a referendum had to be held on a date no later than the 31st of December 2017 on whether the United Kingdom should remain a member of the European Union, and it specified the question which should appear on the ballot papers. The remaining sections were really of no relevance. Now, I would suggest that if the Parliament is to take a major step towards any sort of action in the future, one could also say, well, where's the referendum? Such examples should have been put in place with respect to the ULEZ campaign that's going through. And also the financial costs and all, which should have been disclosed and weren't. The referendum duly did take place in the United Kingdom on the 23rd of June 2016. And it's, according to this, it says the majority in favor of leaving the European Union. Now, whether that's accurate or whether that was done by an independent third party, who knows, right? And then on the 7th of December 2016, following a debate, the House of Commons resolved to recognize that the House should respect the wishes of the United Kingdom as expressed in the referendum. Okay, and call the government to invoke Article 50 by the 31st of March 2017. This indicates now that we have a government which is trying to represent the people as it's supposed to, and it should have a majority vote. Yet many times the government implements certain laws or provisions within the law which do not represent the people, and as such people have a common law right to refuse. We will get further into this later in this presentation. Okay, now it says here under point 34, the Secretary of State case is based on the existence of a well-established prerogative power of the Crown to enter into and withdraw from treaties. So they're indicating here that the Crown, being the monarch, is still part of the legal system. Okay, he contends that the minister is entitled to exercise this power in relation to the EU treaties and therefore give notice without the need for any prior legislation. That's true based on the treaty, if I understand the treaty correctly. I haven't read the entire thing. At this point, does it really matter? We've exited the European Union, and does it make any difference? Okay, and this was the Great Repeal Bill. It'll be laid before Parliament, and this will repeal the 1972 Act, which means cancel it, wherever practical. So they're indicating that even though the Act itself may be cancelled, certain points of it are not practical to just dissolve, and therefore it will convert existing law from the EU law into domestic law. It says right here, it says we'll convert existing EU law into domestic law, at least for a transitional period under Article 50. That means that any law that's on the books prior to exit will be converted where practical. And then it gives them a time frame of 2 years to exit. And that's it. And after that, the Great Repeal Bill will come into force. So 2 years from 17 makes it 2019. Now, it was made clear that Secretary of State intentions are not law, and the courts cannot proceed on an assumption they will necessarily become law. This is a key point, because if the law is intended to change and the court system tries to push the law through as though it has already taken place, that would be illegal. This does happen from time to time, and so therefore I bring this point up. Okay, if it's a matter of Parliament to decide in due course then that issue's got to be resolved in accordance to law before it stands in law. Meaning if something's proposed and that hasn't happened yet, it's of no force and effect. Point 41, the Crown is subject to limitations, were ill-defined and were changed with practical existence. This is how the creation of law actually happens. Laws change over time. Accordingly, the Crown is largely exercising all of its powers of the state, and this goes back to the 11th century. And the kings rarely attended meetings in council. Well, that was their discretion. However, over the centuries, those prerogative powers, collectively known as royal prerogative, were progressively reduced as parliamentary democracy and the rule of law developed. By the end of the 20th century, the great majority of what had previously prerogative powers, at least in relation to domestic matters, had become vested in three principal organs of the state: the legislature, which is the two houses of parliament, and the executive ministers, and the government, more generally the judicial and judges. This is telling you right now that the current law system we have is not receiving royal assent. This is also telling you that if it doesn't receive royal assent pursuant to the Great Seal Act, which we've covered in a previous presentation, makes them null and void. Okay, it is possible to identify a number of summarial events in this importance. And those statutes were, and still are, the Bill of Rights 1688, 1689, and the Act of Settlement 1701 in England and Wales, and a Claim of Right Act in 1689 in Scotland. These acts of the Union in 1706 and 1707 in England and Wales, and Scotland respectively. Northern Ireland joined the United Kingdom pursuant to the Acts of Union in the 1800s. So they're still referring back to these original statutes. And I covered some of that in a presentation called Primary Legislation. So if they're still being referred to in this case today, then obviously they're still valid. And in fact, they are still valid. So it's telling you right here that they were of particular legal importance. Well, they still are, because the current government, as it's stated in this paragraph, is creating laws and legislation and acts and statutes, but they don't comply or confer with the primary legislation, as I call it, going back to the 1688 timeframe. The independence judicial was formally recognized in the statutes in the broadest sense, in the role of the judiciary to uphold the further rule of law, and judges impartially identify and apply the law in every case brought before the courts, or at least they're supposed to. This is why and how these proceedings are being decided. The law is made in order under statute, but there are areas where law has long been laid down and developed by judges themselves. This is the common law. Common law, basically, for those that don't understand, is a basic rule of law that's been practiced over years and years and years and now becomes commonplace. And it's the rights of the individual over statutory rules. Okay. However, it is not open to judges to apply or develop the common law in a way which is inconsistent with the law as laid down in or under statute, i.e. by acts of Parliament. So they're telling you right here that the common law still exists, and the judge doesn't have the authority to alter the law or alter the judgment based on his or her whims. They must follow common law. This is very important because the British UK Parliament and the British UK legal system is based initially on common law. And common law supersedes statutory law. Okay, now it says on point 43, this is because parliamentary sovereignty is a fundamental principle of UK Constitution. So that's telling you that parliamentary sovereignty is a fundamental principle. But parliamentary sovereignty doesn't give them the authority to overrule common law or laws of equity, cases of equity. This was summarized by Professor Dicey. If anybody wants to do any legal research, they should look into Professor Dicey. And there's a couple other people that are worth mentioning as well. But as the meaning of Parliament is the right to make or unmake any law whatsoever, and further, no person or body is recognized by law as having the right to override or set aside the legislation of Parliament. So if the legislation of Parliament goes back to 1688, it's telling you that you have the right to use these acts and statutes. The legislative power of the Crown is today exercisable only through Parliament. So therefore, if the exercise of law, which we can call statute, is done through the Crown, then it must receive royal assent, which is consistent with the Great Seal Act. Okay, this power is indicated by the laying of a bill containing a proposal before law before Parliament. The bill can only become statute if it is passed, often with amendments by Parliament, which normally, but not always, means both houses of Parliament, and is then formally assented to by H.M. the Queen. Well, that's incorrect, because after the 1800s, most laws don't receive royal assent. Thus, Parliament, or more precisely the Crown in Parliament, lays down a law through a statute, or now they're calling primary legislation, as is known, and not any other way. Well, they're telling you here that it has to go through H.M. the Queen. So H.M., for those that don't know, is Her Majesty the Queen. Well, now it'll be King. But also, it can't violate what I was referring to as primary legislation of 1688. In the early 17th century, case of proclamation in 1610, it said that the king, by his proclamation or any other way, cannot change any part of common law or statute law or the customs of the realm. This goes back to your Bill of Rights of the 1700s or 1701. So they're asserting here that the king and or queen can't change any part of common law. So again, they're recognizing common law or statutory law or the customs of the realm. Now, if we go back to the primary legislation demonstration that we did, we talked about the fundamental rights of people and how the laws can't be to the prejudice of the people. Okay, this statement is controversial over time, has come firmly established by suspending of laws or execution of laws by regal authority without consent of Parliament is illegal. This again confirms that everything must pass through and receive royal assent. Because as I stated earlier, and as was indicated in the text, ministers are not allowed to just make whatever laws they want without going through the proper channels. Okay? And exercising as of late is illegal. Well, most of the laws we deal with, after the late 1700s, is not legally binding. Okay. In Scotland, the Claim of Right 1689 was the same effect, providing that all proclamations asserting and absolute power to cast, i.e. to quash or anneal or disassemble laws are contour to laws in Scotland should remain in the same force as before. So in other words, if they can't quash a law, which means cancel it, those laws are still relevant, meaning that if we have an older law that's still on the books, you can still refer to it. Okay? So that's fairly straightforward. Now, the exercising of those powers can be compatible with current legislation and or the common law. So again, we can refer back to common law and assert our rights that way. Okay? They can infringe on a law which, as just explained, they can't do. So if those laws infringe on your rights under common law, they're to that extent null and void. Okay? Now, they can't prescribe or alter law to be administered by the courts in this country or various branches of the executive courts, and they can't make rules in having force of statute because all of them would be deriving their validity from the what I call primary law, which creates the power. If we go to the next point, 45, the Crown administrative powers are now exercised by the executive, i.e. ministers, who are answerable to the UK Parliament. So if a major law is going to come into place, I would suggest that the UK Parliament has to do a referendum, just as they did to exit the European Union. Okay, and it says, however, consistently with the principles established in the 17th century that exercise those powers must be compatible with legislation and the common law. Again, this is asserting that we can go back to our what I call primary legislation of the 1688-1700 range, as well as common law, and use those rights to assert our rights within a court. Otherwise, ministers would be charging or infringing on the law. So that's pretty straightforward. And it also gives you a legal reference here by Lord Parker. Okay. At point 46, it says it's true that ministers can make laws by issuing regulations and the like. And but it also states that they can only do so if authorized by statute. So if the regulations are not authorized, they will be invalid, even if they've passed an approval and a resolution by both houses under the provisions of the relevant enabling act. Okay? And it gives a court case for relevant example, CR, the Public Law Project versus Lord Chancellor. That's to say that if the government passes a law in the two houses of Parliament and it's supposedly an act or a statute, unless it receives the proper authority under royal assent, it's null and void. When's the last time a document's actually received royal assent? Is sometime in the late 1700s. Point 47 of this document is rather important. It says basically the powers which remain vested in the Crown are exercisable by ministers, provided that the exercise is consistent with parliamentary legislation. So, in other words, if they try to pass something through which hasn't received royal assent, then it's null and void. And it gives a couple of court cases here. The royal prerogative is a source of power which is only available for cases not covered by statute. Now, in times of war, the government can suspend these regulations and can basically do what it needs to do in terms of military defense. Okay? It says right here, the residual power prerogative is now conferred in such matters as summarized in dissolving Parliament, declaring war and peace, regulating armed forces, and in some respects governing certain colonial territories, making treaties. So that tells you that they can suspend certain rights or certain regulations in a time of war. However, we are not currently at war, so therefore your rights and liberties remain intact. If we look at point 48 of this document, we see some very interesting points here. It says basically, to interfere with the property or liberty of subjects has been placed under parliamentary control and directly regulated by statute. That's correct, because primary legislation, back to the 1688-1700 range, is the statute which regulates your rights and the rights of the subject. It goes on further to say that they no longer derive its authority from royal prerogative of the Crown, but from Parliament, and that in exercising such authority, the executive is bound to observe the restrictions which Parliament imposed in favor of the subject. You are the subject, and therefore, under that rule, that regulation, you can go back to primary legislation, 1688, which is the Act of Will and Mar, the Bill of Rights, 1688, and the Coronation Oath, and then the Act of Settlement, 1700-1701. So, because it says in favor of the subject. Therefore, any law that's repugnant to the subject's rights, meaning repugnant to your rights, is to that extent null and void. At point 50, we see the passage quoted by Professor Wade in paragraph 47 above is the fundamental principle of the UK Constitution, that unless primary legislation permits it, the royal prerogative does not enable ministers to change statute law or common law. So here they're referring to primary legislation as the fundamental creation of government, which goes back to 1688 to 1700s. Okay, so it says right there, does not enable ministers to change statutory law or common law. And then it gives the couple of court cases that verify that. So you can quote that as well. Okay, it does not empower the Crown to change English, common, or statute law. This is the powers must therefore be consistent with both common law as laid down in the courts as with statutes as enacted by Parliament. So they're telling you right there that you can rely on those fundamental primary legislation, as I've went over in a previous document, previous presentation. At point 52, the case becomes rather interesting. It says the facts that exercise of prerogative powers cannot change domestic law does not mean that such exercise is always devoted to domestic legal consequences. So what they're telling you here is they can change certain laws based on the servants of the government. And it says the inherent that the power of the Crown can alter those terms is to remove rights, albeit such power is susceptible to judicial review. But if we refer to the cases referenced here, Council of Civil Service Union versus the Minister of Civil Services, 1985, so they're referring to a contract that they have with an arm of their government. It doesn't apply to you because you still have the rights under the common law and under the precedent statutory law as referenced under my primary legislation video. Okay. Now, the Crown also has the prerogative power to destroy property in wartime in the interest of national defense. So they don't have the right to destroy property unless we're in an act of war under national defense, although at common law compensation was payable. So if you're in common law and the government destroys your property for some reason, you have a right to compensation. This also gets into when they expropriate land, which is a subject for a different presentation. While the exercise of prerogative power in such cases may affect individual rights, the important point is that it does not change the law, because the law has always authorized the exercise of this power, but only in the case of defense, national defense. This is applicable now if the government's trying to take or has taken your property, because you are entitled to compensation, as stated in the above case. At point 55 in this document, we find something rather interesting. On the last paragraph, it says the second proposition is that although they are binding on the United Kingdom in international law, treaties are not part of UK law and give rise to no legal rights or obligations in domestic law. This would indicate now that we have no rights under domestic law to control the treaty, which is in fact true, because our domestic law was based on the laws of the EU at that time, and those laws have not dissolved as we've covered earlier. However, the UK government has the right to withdraw from a treaty if it feels justified to do so, and if the provisions of the treaty allow such withdrawal, which in this case they do. Based on that, there is no fear that the laws or changes in law will affect you. Okay? They give no legal right or obligation in domestic law. What I stated in the previous slide is clearly expressed here. It's the basis of these two principles that the prerogative power to make and unmake treaties is consistent with the rule that the ministers cannot alter UK domestic law. And it gives a couple of court cases. Lord Huffman pointed out that the fact of the treaties are not part of domestic law was the corollary for the Crown's treaty-making power. And then it cites the case. Now, it's quoted in there as stating, as a matter of constitutional law of the United Kingdom, the royal prerogative, while embraces the making of treaties, does not extend to altering the law or conferring rights upon individuals or depriving individual rights which they enjoy in domestic law. Without the intervention of parliamentary treaties, as is sometimes expressed. So this clearly states that if you have a right under the treaty that was given to you under that treaty, it doesn't simply dissolve because they've exited. Quite simply, a treaty is not part of English law until it has been incorporated into domestic law by legislation. Therefore, you're safe, right? People have asked about it. There's your proof. At point 57, we find out a very interesting point. The point, in another way, is to exist the parliamentaries, not ministers, summarizes a position, and it says, if treaties have no effect in domestic law, parliamentary legislative supremacy as its own policy is secure. If the exercise must always seek the sanction of Parliament in the event that a proposed action on an international plane will require domestic implementation, parliamentary sovereignty is reinforced at this very point that the legislative power is engaged. So what they're telling you here is Parliament can do basically what it wants. But it also goes down and it says at point 58 that while ministers have in principle unfettered power to make treaties which do not affect or change domestic law, it has become fairly standard practice in the late 19th century for treaties to be laid before both houses of Parliament at least 21 days before they were ratified, to enable the parliamentary objections to be heard. Well, this has to do with the creation of laws within government, and in order for any law to be lawfully imposed by government, operating under the British realm or the British realm's method of creating that law, one House of Parliament imposes an idea, the second House of Parliament reviews the idea, and then it goes through a general debate from both houses, and then it's supposed to be announced publicly for the people to have an input before it passes third reading and becomes actual law. Any law that does not follow this protocol is in fact void or can be voided. And these changes in law or in statute must be posted to a gazette. And depending on where you are, the gazette will change. And if they're not posted for public input, then they're in fact void. Now, this could be particularly advantageous to anyone wishing to challenge the ULAS law or any other law, because if it wasn't publicly posted, it is of no force and effect. Okay? This has to do with the constitution of the country. And if the people are supposed to have a voice under common law, and they don't know certain laws are being passed or the ramifications thereof, then how can the law even be legally binding or valid? If we look at point 62, it said the 1972 Act did two things which are relevant to those appeals. First, it provided the rights and duties and rules derived from EU law should apply in the United Kingdom as part of domestic law. Secondly, it provided for a new constitutional process for making law in the United Kingdom. These things are closely related but are legally and conceptually very distinct, separate. The content of the right and duties and rules introduced into our domestic law as a result of the 1972 Act is exclusively a question of EU law, However, the constitutional process by which the law of the United Kingdom is made is exclusively a question of domestic law. So they're stating here that because it says in the first paragraph that anything derived from EU law should apply to the United Kingdom as domestic law, then any domestic law which is now in force prior to the exiting of the EU treaties is still domestic law unless it's repealed by the government. This goes back to what I said in an earlier slide. Under the terms of the 1972 Act, EU law may take effect as part of the law of the United Kingdom in one of three ways. First, the EU treaties themselves are directly applicable by virtue of Section 2, Sub 1, and some of the provisions of these treaties create rights and duties which are directly applicable in the sense that they are enforceable in UK courts. Secondly, where the effect of the EU treaty is that the EU legislation is directly applicable in domestic law under Section 2, Sub 1, provides it has the direct effect in the United Kingdom, without the need for further domestic legislation. And this applies to EU regulations which are directly applicable by virtue of Article 288 of the TFEU. Third, Section 2, Sub 2 authorizes the implementation of EU law by delegated legislation. So they're telling you here that even if there isn't specific legislation on the books, you can still refer to this EU legislation. This applies mainly to EU directives, which are not generally directly applicable, but are required, again by Article 288, to be transposed into national law. So we can refer back to the old EU laws if we wish. While this is an international law, directives may be enforced by individuals directly against national governments in domestic courts. Again, affirming that we have the right to refer to these laws. Okay? Fairly straightforward. It gives a couple of court cases. At point 64, it says, thus EU law and EU treaties and EU legislation will pass into UK law through the medium of Section 2, Sub 1, or the implementation of provisions of Section 2, Sub 2 of the 1972 Act, so long as the United Kingdom is party to the EU treaties. Similarly, so long as the United Kingdom is party to the EU treaties, the UK courts are obligated to interpret EU treaties, regulations, and directives in accordance with the decisions of the Courts of Justice, and to refer unclear points of EU law to the Courts of Justice, and to interpret all domestic legislation as if all possible to comply with the EU law. And then it gives the court case. So long as the United Kingdom is party to the EU treaties, UK citizens are able to recover damages from the UK government in cases where decisions of one of the courts of the state are based on serious error of EU law and has caused them loss. So we can now refer to any case that is inconsistent, the findings of are inconsistent with EU law, and potentially seek compensation, if you will, for that act. Now, on point 65, in our view then, although the 1972 Act gives effect to EU law, it is not itself the originating source of that law. It is, as was said on behalf of Secretary of State, Professor Finnis, the conduit pipe by which EU law is introduced to UK domestic law. So long as the 1972 Act remains in force, its effect to contribute to constitute EU law is independent and overriding source of domestic law. So they're telling you that the EU law is an independent and overriding source of domestic law, which is very similar to what I stated earlier. Therefore, you can use that as a reference if needed in any court case. At point 66, it again confirms that Section 18 of the 2011 Act, set out in paragraph 30 above, was enacted in order to make it clear that supremacy, if we want to call it that, of EU law over domestic legislation did not prevent it from being repealed by domestic legislation, but that is confirmed that the position, as it has been since the beginning of 1973. The primacy of EU law means that unlike other rules of domestic law, EU law cannot be implicitly displaced by a mere enactment of the legislation which is inconsistent with it. This again confirms and reaffirms that what I said earlier, you can always refer back to EU law if it is current and relevant and in force or was in force prior to the exiting of the British from the EU treaties. And it goes on further to reference a court case. At point 67, we see here again that the EU law has primacy or supremacy over the British English law to the extent that the law will allow. It will therefore have the status only for as long as the 1972 Act continues to apply, and that, of course, can only be a matter for Parliament to decide. So if Parliament decides to exit, then it's telling us that the EU laws will no longer have primacy or supremacy over the British laws. However, it doesn't dissolve the laws which are already and have already been enacted by the British Parliament. At point 69, it says that although Article 50 operates in a plane on international law, it is common ground that because EU treaties apply as part of the UK law, or domestic law will change as a result of the United Kingdom ceasing to be a part of them, and the rights enjoyed by UK residents granted through EU law will be affected. This is true because when the British government or the British Parliament was part of the EU, you could import and export things easier. You could travel more freely without having some certain restrictions in place. But the divisional court, which is a form of an appeals court, concluded that because ministers can't claim a prerogative power to take an action which would result in a change in domestic law, they couldn't withdraw from the EU treaties in that way, and therefore to serve notice without authorization in a statute. This means, again, that they have to get their authority from a statute before they can change laws, and therefore certain rights would have to be repealed or cancelled. In connection, the divisional court identified three categories as of a right of the people, which is you guys. The rights capable in replication in UK law. So unless there's a UK law that can replace the right that you had previously, then the right still exists. Rights derived by UK citizens from EU law in other member states. So if you had that right before, again, you still have that right. Rights of participation in EU instructions that could not be replicated in UK law. So in other words, if you had that right under a UK law, that's fine. But if you didn't have that right and it was under an EU law, then unless it's been replicated in the UK law, you still have those rights. Again, asserting that your rights did not change because we exited the UK. As far as domestic law goes, it does affect your rights to travel and import stuff from other EU states. These points are again confirmed in point 70. It says many current EU rights fall within the first category. They include, for instance, the rights of UK citizens to benefit from employment protection, such as Working Time Directive, to equal treatment, and to the protection of EU compensation law, and the right of non-residents to benefit from four freedoms: free movement of the people, goods, and capital, and freedom to provide services. Some of these rights already been embodied in UK law by domestic legislation pursuant to Section 2, Sub 2 of the 1972 Act, and they will not cease to have effect upon the United Kingdom's withdrawal of the European Union, unless domestic legislation given them effect is to be repealed. This is confirming again what I said, in accordance with the law. Although the Court of Justice will no longer have any binding role in relation to the scope of this interpretation, other rights arising under EU regulations or directly under EU treaties will cease to have an effect upon the withdrawal. So again, if you had those rights, you still have those rights, unless they've been changed by domestic law. Okay? Page 25, yeah, okay. At point 77, it says, we also accept that Parliament cannot have the intended that Section 2 should continue to import variable content into EU law into domestic law. So basically they're stating that they're no longer going to use the EU law and import it directly into domestic law. It's no major issue in this case. At point 79, it again affirms that even though that we are being withdrawn from the EU treaties, it does not infringe on our rights that were given to us under that treaty for the time that we were a part of it. At point 80, it again affirms that the EU law may cease to be the source of domestic law, but the rights that were granted to us from that law still remain in effect, unless there's a change in the law itself directly. These legal rules derived from EU law, transposed into UK law by domestic legislation, will have a different status, but it'll still exist, and they'll be open to domestic repeal or amendment in ways that may be inconsistent with the original provisions of the treaty under EU law. Again, confirming that they have to repeal it in order for it to be cancelled. At point 81, it basically states that EU law is no longer the supremacy law and will not be used as a primary law or primary source of law once the British exit EU. And it will not be given the supremacy in domestic law like it used to be. In fact, it won't be given any supremacy at all. Point 82 again confirms that any law that was consistent and on the books prior to exiting the EU treaty is still a specific requirement. Those EU laws are still binding domestically and still do apply. At point 83, it says basically that even though the source of the law is now changing from EU to the UK Parliament, and based on the decisions of the ministers, doesn't really affect the UK citizen. Point 91 of the document indicates that the ministers could have taken a course to exit the European Union even if there had been no referendum, or indeed, at least in theory, even if the referendum had resulted in a vote to remain. I don't entirely agree with this fact, but that's the way it is. But it indicates that a referendum is needed before a major change, or at least a potential referendum is needed before a major change happens in law. At point 99, if we read through it, it refers to Lord Denning, which is yet another name to do some research on, if in fact you're engaged in some sort of a legal matter, and it references a number of cases. But it says basically that EU law is part of domestic law, so there's no disputing anything. Unless domestic law gets changed by a statute or repealed, that law still stands, which is consistent with what I said earlier. At point 108, we find some more interesting information. They reference a couple of cases, and it says the fundamental rights cannot be overwritten by general words in a statute because there's too great a risk that the full implication of their unqualified meaning may have passed unnoticed in the democratic process. If this is true of general expressions in statute, it must be a principle that is applied to omissions in a statute. So if they omit to say something in any statute, then you can infer that you probably have that right, provided it's logical, of course. Okay? Now it also says certain other decisions require a motion to be agreed in both houses of Parliament before the UK could vote in favor of a specified decision in EU instructions, basically. Well, you could argue the point and say, well, if any major action is going to take place within the UK, it would require to be passed in both houses of Parliament, and as I stated earlier, would also require the notification to the public and to be posted in the Gazette in order to be valid. If someone was to challenge certain laws, they may look at the Gazette and see if this public posting, which is a requirement of law, has actually been done. In many cases, these postings are not done, and their laws and statutes are enacted privately behind closed doors without any notification to the public. This would therefore give the public grounds to challenge the validity of any enactment or law that has been passed in such a way. To further affirm my position that certain laws and certain constitutional practices have still remained even after we've exited the EU, even though they were part of the EU's original legal system. Point 114, post-1972 history on the applicants relied was the effect of the 2002 Act as explained in paragraph 27 above. The Act gave most people of the United Kingdom the right to vote in an election for an MEP and the right to stand for election as an MEP. On the face of it, these freestanding rights abet the 1972 Act and are domestically granted in primary legislation passed by Parliament. The Secretary of State can't argue that these rights are in any sense ambiguatory, and these rights which would be lost if the United Kingdom was to withdraw from the UK treaties. This is affirmed now because we've also had 3 constitutional referendums on the EEC membership in 1975 and on the parliamentary election voting system in 2011 and on the EU membership in 2016. These have also been dealt with relation to Scotland and political parties and elections and Referendums Act is current legislation, and we have the right to vote for our elected officials. So even now, even after 2016 and the exit of Britain from the EU treaties, these acts remain in force and remain in effect. They have not been repealed, as I stated earlier, which would be a requirement for us to lose any of the rights that were afforded to us as a result of joining the EU back in 1972. At point 125, the second paragraph, it states, because the sovereignty of Parliament referendums cannot legally be binding in the UK and are not therefore adversary, however, it would be difficult for Parliament to ignore the decisive expression of public opinion. This indicates now that the public opinion does have an effect on the government. The UK government's response, as recorded in the committee's 4th report, session 2010-11, was that the government agrees with this recommendation. Under the UK's constitutional agreements, Parliament must be responsible for deciding whether or not to take action in response to the referendum results. This indicates again that the referendum has legal standing, contrary to what was stated earlier in the case, and the government's in fact agreed to this fact. Therefore, we should have referendums on a number of topics, including the implementation of ULEZ and others. If we read point 141, it comes up to a very interesting point here. It says, before addressing the more recent legislative recognition of the conviction, it is necessary to consider the role of courts in relation to the constitutional convictions. It is well established that the courts of law cannot enforce a political conviction. And it goes on further. It talks about resolution to the arm of the Constitution, 1981, which is a Supreme Court ruling, and the Supreme Court of Canada addressed the nature of these political convictions. Now, I brought this forward because many people have asked me, well, how can we reference or how can we make use of a case that did not happen inside the United Kingdom? Well, the truth of the matter is that any government that operates under the British realm, the cases can be suggestive in nature if they're used in another part of the British realm. That is to say that if I want to reference this Canadian case for some particular reason, or any Canadian case, or any case that's been used in another British realm, I can do so. It doesn't have the same force and effect as if it happened in the UK, but it does suggest to the court of a thing to consider. Now, courts of lower authority, lesser courts if we want to call them that, are supposed to take their judgment and their determinations from higher courts. Okay? Now, a similar approach can be seen in more recent cases. In the Samori case in 1916, an issue arose whether the courts were bound by an order in council made under the prerogative power to decide that a neutral ship found during wartime to have contraband cargo on board. So they're again going back to 1916 in this case, okay? Now, was it really destined for the enemy? Who knows? That's a constitutional issue. And administrated by the courts of law of the country, is out of harmony with the principles of our Constitution. No one would be content that the prerogative involves the power to prescribe or alter the law administered in the courts of common law or equity. This, again, is another important point that, again, I repeat, it says no one would contend that the prerogative involves the power to prescribe or alter the law administered in courts of common law or equity. This affirms now that common law courts or courts of equity supersede statutory courts. Now, many people say, well, what the heck does that mean? Well, a court of equity means you have a financial or physical investment in something. Well, this applies to most things because if you're dealing with anything that you've purchased, you put in some equity, you will call it sweat equity, which resulted in financial equity or a financial claim. So that would be a law of equity or a claim of equity. And common law, as some people say, well, common law, statutory law, what's the difference? And it states right here in the last paragraph that the courts are not involved in any power to prescribe or alter the laws administered in a court of common law. This affirms then that we have a court of common law, or we can rely on a court of common law, or a court of equity. Now, under statutory provisions, common law and the court of equity take superiority. And more specifically, if someone has an equitable claim, the statutory courts have no authority to mess with that. This is very important because most claims that the courts make are in fact claims of equity, and the real person with equity 9 times out of 10 is you, the defendant. Very, very important. It's probably one of the most important points in this entire case. Point 168 affirms again that the Crown can't alter common law or statute by its exercise of its prerogative power, which was developed in the case of the Attorney General versus the Royal Hotel Limited in 1920. That is to state that if the government or court, because the court is in fact the government, operates outside of the statute, if the whole grounds of something which could be done by prerogative covered within the statute, it is the statute itself that rules. A further point brought up at point 230 is basically stating that because the 1972 Act created a new source of law which can't be revoked without further legislation, would indicate that any laws that were brought forward as a result of that treaty are still in force and effect because they haven't had any legislation to repeal them. Okay? Point 255 is another interesting point, and it states here that the Parliament has a responsibility to properly scrutinize the government while respecting the decision of the British people to leave the European Union, and has acted by calling on the government to invoke Article 50 by the 31st of March. This again affirms that the government should be and can be ruled or regulated by any sort of enactment based on a referendum. So the people are the voice of the government, or at least that's the way it's supposed to be. Okay? It states, of course, the House of Commons is not the same as the Queen in Parliament, who is represented exclusively by primary legislation. This goes back to my original argument of primary legislation and how things must be authorized by the Great Seal with consent of Parliament. This clearly defines now that Parliament is not the Queen. Parliament is not the same as the Queen in Parliament. It's clearly stated, so there should be no more dispute regarding that matter. Okay? If we read point 256, it states the logical starting point for consideration of the present case is the power which is in issue. That is the power under Article 50 of that treaty to initiate the procedure of withdrawal by decision in accordance with the constitutional requirements, followed by a service of notice. The existence of that power in international law is not in doubt. The issues for the court are, first, who has the right under UK constitutional principles to exercise it, and secondly, subject to what constitutional requirements. As to the first, under the Tin Council principles, the position is clear. In the absence of any statutory provisions to the contrary, the power to make or withdraw from international treaty lies with the executive exercising of the prerogative power of the Crown. As to the second, it is necessary to consider whether that power is subject to any restrictions by statute, expressed, implied, or the common law. What they're stating here is it has to be constitutional and it has to follow common law. So again, we're asserting the rights that we have a constitution, and the laws and statutes and acts must be consistent with that and or in the common law. So it has to comply with one or both. Now, because the British legal system is based on common law, as we've expressed earlier, I would suggest that it has to comply with both. Under point 259, it says, turning to the common law, the Tin Council rule is simple and uncontroversial. The prerogative does not extend to altering the law or conferring rights upon individuals or depriving individuals of rights which they enjoy in domestic law without the intervention of Parliament. Therefore, they're not allowed to step on your given rights, and even if they do withdraw, they can't take away those rights. Judged by the test answers again, it is clear. Service of Article 50 sub 2 notice will not and does not purport to change any laws or affect any rights. Again, this affirms what I said earlier. It is merely the start to an essential political process of negotiation and decision making within the framework of that article. Okay? True it is not that it is intended to lead due course to the removal of EU law as a source of rights and obligations under domestic law. So again, they're asserting that even if we leave, and now that we have left, it doesn't take away your rights. Okay? Okay? The negotiations of any contents and any resulting agreement still would stand. Furthermore, whatever the shape of the ultimate agreement or even the default agreement, there is no suggestion by the Secretary of State that the process can be completely without primary legislation in some form. So they have to have some sort of a law that would support the rights that you already had, or they're going to have to leave the existing ones there. The only difference now is that the EU will not be the overriding supremacy or primacy rule of law. All this thing did was separate the source of law. At point 260, if we read partways down, it says it's the beginning of the process which will ultimately and probably lead to changes in United Kingdom law on the day after the notice has been given. The law will in fact be the same as it was the day before it was given. The rights of the individual citizens have not changed. So again, they're affirming that the rights of the UK citizen do not change once the UK citizen or UK government leaves the EU. Okay? It may be the subject to changes down the line, but it doesn't change just because we've exited the EU. Upon review of point 263, second paragraph, we will start by bringing forward the Great Repeal Bill. That will mean that European Communities Act 1972 ceases to apply on the day we leave the EU. The Great Repeal Act will convert existing European Union law into domestic law where practical. Again, this affirms that we will not lose any rights now that they've left the European Union. Okay? This will provide for a calm and orderly exit and give as much certainty as possible to employers, investors, consumers, and workers. In all, there are more than 40 years of European Union laws in the UK to consider, and some of it simply will not work on exit. We must act to ensure that there is no black hole in our statutory book, or statute book. This will be for the House. I repeat, the House to consider changes in our domestic law legislation to reflect the outcome of our negotiation and exit, subject to the international treaties and agreements with other countries and the EU matters on such trade. So again, they're telling you right here, they're not just abolishing every right that we ever had, but it's subject to modifications in the future. 264, on the assumption that the bill becomes law by the time of withdrawal, there will be no breach of the rule in its classic form. Okay, so there will be no changes or rights taken away. So again, they're affirming that even if we left, nothing's changed. Okay. Upon review of Section 270, it's kind of misleading, but it tells you here the Immigration Act of 1988 provides that a person shall not require leave, which means permission, to enter or remain in the United Kingdom, in any case in which he is entitled to do so by virtue of enforceable by EU right. So you can rely on your EU rights again to remain in the United Kingdom. This has been a quick and brief overview of the case, and it is suggested that all people read that case and understand the implications of what's stated within it. This has been a brief and very quick overview of the one particular case, which brings up many legal points and some precedent case law, which can be used in various ways with various different legal arguments or legal cases which you may be involved in. It was presented to hopefully clarify and provide some assurance to people who are now afraid that this exit from the EU will result in the loss of rights. It was also presented in a way that would show that even though laws may be pertaining to certain areas, such as Canada in this example, those same laws can be referred to in EU and or in the British Commonwealth, which includes the United Kingdom, of course. It also shows that the government cannot operate outside its legal framework as prescribed by statute. That's clearly demonstrated in one of the slides back there that says if the provisions are regulated by the statute will prevail. I've also demonstrated that if the court operates outside the statute, it's of no legal force and effect, and I've demonstrated that you can rely on precedent case law because they refer to precedent case law back in the 1920s, and they also refer to the Bill of Rights and other laws which were in place in 1688, and as such we have that same legal right, and if they can use it in an appeals case, we can certainly use the same arguments in any case that we may be involved in. If you have any specific questions regarding legal matters, I can be reached at deniedtruth@yahoo.com, or you can reach the Telegram group at the link directly below it. I also have a YouTube channel, which is www.youtube.com/@StanMcDonald. At that YouTube channel, you will find a variety of short presentations ranging from 20 minutes to about an hour, as this is the longest presentation, and it covers a variety of topics, including challenging council tax, dealing with affidavits, how to file court forms, a review of this case, obviously, and other legal presentations which you may find helpful and or beneficial. I thank you for taking the time to listen to this presentation. I hope you found it informative, and if you have any specific issues, please reach out and I'll do my best to address your situation. Thank you for taking the time to listen to this presentation. I look forward to providing you additional information in the future. Thank you.